Good afternoon. Welcome to the webinar presented by U.S. Drug Test Centers, all about DOT oral fluid drug testing and what you need to know. So we're going to cover that topic today. We have a pretty good crowd, and I just want to make sure. Okay, Kelly's telling me that she can hear me, so you guys can hear me, and we'll go ahead and get started. My name is Joe Riley. I am the presenter for today. I am a consultant and a trainer for U.S. Drug Test Centers. I've been in the drug and alcohol testing industry for 30 years now. This is my 30th year. It's an exciting time because this is a huge, major change to DOT drug and alcohol testing. So if you're an employer and you're regulated by DOT, this is a huge change. It affects all DOT agencies, FMCSA, FAA, FTA, FRA, PISMA, and U.S. Coast Guard, which is under Homeland Security, but they follow DOT regulations for drug testing. If you're a collection site collecting specimens for DOT drug testing, this is a major change. If you're a TPA, an MRO, any kind of service provider in the DOT drug testing arena, this is a major change. So today's topic is DOT oral fluid drug testing, what employers need to know. If that's not the topic you're looking for, you're on the wrong airplane and you won't arrive in Las Vegas today. So let's get right into it. DOT published a new drug testing rule. They published it on May 2nd of this year. It's a final rule that, among other things, authorizes employers to use oral fluid drug testing as an alternative testing methodology to urine drug testing. So this does not replace urine, it's an alternative. This final rule also harmonizes 49 CFR Part 40, the DOT rule for drug testing, with pertinent sections of the Health and Human Services oral fluid mandatory guidelines. United States Department of Health and Human Services authorized oral fluid testing several years ago and published those in their mandatory guidelines, but DOT did not publish their final rule until just 2 months ago on May 2nd. This published rule clarifies certain Part 40 provisions that also cover urine testing procedures, and it removes some provisions that are no longer necessary. It adds some new definitions and some clarifying definitions and some web links, and updates provisions to address some issues that have risen in years. So basically, DOT took the opportunity, since they were kind of publishing a new version of 49 CFR Part 40 to include oral fluid drug testing. This new version addresses some other things also. So first, we'll cover the oral fluid drug testing, and secondly, we'll cover some of those other things that happened into the rule. So as I mentioned, this applies to all DOT agencies. So any employer regulated by the United States Department of Transportation, either in the FMCSA program, FTA program, FAA program, FRA program, PISMA program, or U.S. Coast Guard program. Does not affect anybody that's not regulated by the United States Department of Transportation, required to follow drug testing, drug and alcohol rule 49 CFR Part 40. This rule was published on May 2nd, 2003, but doesn't take effect until June 1st. So it took effect June 1st, 2023. However, DOT oral fluid drug testing is not currently operational. DOT oral fluid testing is approved, but will not be available until at least 2 laboratories are certified by the Department of Health and Human Services, HHS, and SAMHSA, both using the same collection device, certified for oral fluid drug testing. We've got over 20 labs that are certified for urine drug testing. We do not have any labs currently certified for oral fluid drug testing. So although the rule is in effect, we have to wait. We don't have anybody to send our specimens to, and we don't have an approved collection device even to collect the specimens. So with urine drug testing, we use a cup and we collect urine. With oral fluid drug testing, we're going to use a device that I kind of call a sponge on a stick that goes into someone's mouth to collect their oral fluid or their saliva. And it's actually going to be two sponges on one stick because we need to collect two samples, one to go in the A bottle, one to go in the B bottle, so that there is a split specimen, a second specimen available if a donor, applicant, employee is requesting a retest, saying the lab made a mistake. They want their specimen tested at another lab. So we need two labs to be certified, at least two labs, one for the initial testing to get us started, and another one to be available if there is a split specimen retest request. Again, the donor is asking that their specimen be tested at another lab. So we need another lab available to do that. So none of this will happen until we have at least two labs certified. The biggest question of the day is when, and it's a guess, and the guess is first quarter of 2024. Now, Quest Diagnostics and LabCorp both have multiple lab facilities. They both have 4 labs around the country. And when we talk about a lab, we're not talking about where your employee goes for their drug test. They go to a collection facility. We're talking about the actual lab that does the testing. So Quest or LabCorp or both, their individual labs are certified individually. So the first one out of the gate could be Quest with their lab in Lenexa, Kansas, and their lab in Philadelphia. Or it could be LabCorp with their lab in New Jersey and their lab in North Carolina. Or it could be one Quest and one LabCorp. Or it could be CRL or Lear or any of the other labs that submit application to be certified. They go through the process and they go through the inspections and the quality control. They get that certification to be able to do DOT employment drug testing with an oral fluid specimen. I want to point out that we have a questions box. If you have questions, please go ahead and ask the question in the questions box. We'll go ahead and answer them as we go. We'll spend some time at the end. We scheduled 75 minutes for this webinar. The content is about an hour, so we got plenty of time for questions, but ask them as they pop into your mind. We'll answer them as we go. Probably somebody's going to ask me about the handouts, the PowerPoint slides. I'm going to provide Catley everybody's email address, and she'll be able to send out the PowerPoint slides and one other handout that we have for this webinar. So both of those will come to you either later today or tomorrow via email. You will get a copy of the slides. You will also get either later today or tomorrow, so at least wait till tomorrow, an email from the GoToWebinar system that will include a recording of the webinar and a certificate stating that you've completed this webinar. So watch for that in your email. If you don't get it by noon tomorrow, check your spam, and then you can reach out via email if there's any issues. But it does come directly from the GoToWebinar system. Okay, so we're waiting on 2 labs to get certified. In the meantime, what's going on? We got new rules for oral fluid testing. We've got an updated published 49 CFR Part 40. It's the overall drug and alcohol testing regulation for DOT. And with this new rule, applicants and employees could be subject to either oral fluid collection or urine collection for any DOT regulated test, pre-employment, random, post-accident, whatever it might be. And if there's a reason that a second collection is needed during a testing event, for example, the initial temperature is out of range, we need a second collection. There's an insufficient quantity of urine or oral fluid, we need a second collection. In the event that a second collection is needed during a testing event, the employer may choose to change to the other type of collection to finish the testing event. So we started with urine, we have a temperature out of range, we need to do a second collection under direct observation. The employer elects to now do oral fluid collection. The choice of whether to do oral fluid or urine is going to be up to the employer. The choice is up to the employer of what specimen to start with, and if there's a need for a second collection, should we switch over to the other one or should we keep the one that we started with? It's not a collector decision. It's not an MRO decision. It's not an employee decision. It's an employer decision. So when should oral fluid testing be utilized? It's up to the employer, but there's one exception. There's one exception when it's required that there be an oral fluid specimen collection. And that exception is when we have a direct observation collection required. So we know that it's direct observation, or we know that it becomes direct observation, and the donor identifies a non-binary or transgender. The donor identifies themselves as non-binary or transgender. The direct observed collection must be with oral fluid. So if it's not a direct observation, it doesn't matter about whether they're transgender or non-binary. The employer decides urine or oral fluid. But once a direct observation is required, the specimen must be oral fluid. Some other compelling reasons for using oral fluid. Oral fluid has a shorter detection window. We're going to detect more recent use of drugs, perhaps use of drugs this morning. So perhaps for reasonable suspicion or post-accident, oral fluid is a good choice. When there's a direct observation, it eliminates that uncomfortable direct observation where a same-sex person must go into the restroom and observe someone observing their private parts, and very uncomfortable. Why not use oral fluid? To avoid a shy bladder 3-hour wait time when someone's having difficulty voiding a urine specimen, they go into the shy bladder and it could be up to a 3-hour wait time. Well, maybe it's a good idea to switch right over to oral fluid. So these are some compelling reasons, okay? So question, what is driving the timeline for approval of the labs and facilities? Are there specific difficulties that they are facing? Once the labs are approved, would there then be separate timeline for collection facilities? Great question, okay? So what's driving the timeline is it's a process. They have to have all their ducks in a row, all the I's dotted, all the T's crossed. They have to do rigorous testing. They have to be inspected. They have to fill out an application. They have to make sure everything works the way it's supposed to work. And it's a process. Okay. So those are the difficulties they're facing. This is all brand new. They weren't going to do any of this stuff until DOT approved it. So now they're starting from scratch. Now, once we have a lab approved and we have a device that the lab is using, the device is FDA approved, which that's in the process Also, collection facilities need to have trained collectors, which we're going to talk about. So they currently have trained collectors, but they're for urine. The training for oral fluid is a separate training, and we're going to talk about that in a minute. So great question. Keep the questions coming. Okay. So when is oral fluid testing required? It's not required, with the one exception that I talked about, and it's worth repeating. When a direct observation collection is required and the donor identifies then as non-binary or transgender, the direct observation collection must be with oral fluid. So again, DOT oral fluid direct testing is an alternative for employer to use at the employer discretion. Urine specimen collection is still an option. The applicant, employee, or collector, or MRO, or SAP, or mom or dad cannot make the choice to use urine, oral fluid, or a combination of both. It is solely an employer decision. The question is, does the employee have to announce that they are non-binary or transgender? If the collection requires a direct observation, then the employee would have to announce that they are non-binary or transgender, and then the direct observation collection must be with oral fluid. Now, that could play out in a different way. Okay, we now have to do a direct observation, Mr. Jones or Mrs. Jones or Bob or whomever, and we're going to have, I'm going to go in the restroom with you and observe you. Are you comfortable with that? And I'm a male, and this person maybe appears to me to be a male. And this person says, well, I'm not a male. I'm not comfortable with you going in the restroom with me. I'm non-binary or I'm transgender and I identify as a female. Well, now they've announced that they're non-binary or transgender. So it may happen in a roundabout way when it comes to that. DOT does not expect this to come up very often. It hasn't come up very often in the past 20 years, but it can and it will come up sometimes. So who decides whether to use oral fluid? This deserves restating for the third time. The employer only has the decision-making authority as to whether to use urine, oral fluid, or a combination of both in their DOT drug and alcohol testing program. So keep those questions coming in. Who can collect specimens for oral fluid testing? Only those who are trained, qualified, and completed what we call proficiency demonstration or mock collections. Now, there may be more than one device that becomes approved in this program. One lab might use one device, another lab might be another device. So a collector that's using multiple labs, sending specimens to multiple labs, and those labs have different oral fluid collection devices, that collector is going to need to be trained and provide proficiency demonstration on each specific oral fluid collection device that they might use. Now, qualified or certified urine specimen collectors, which there's 20,000 plus of them throughout the country, as we speak today, are not qualified to do oral fluid testing until they get trained and qualified for oral fluid testing. Can employers perform in-house oral fluid specimen collections? Well, yes. They can also perform in-house urine specimen collections. They've always been able to do that if they have trained and qualified urine specimen collectors, and for oral fluid, if they have trained and qualified oral fluid collectors. So some employers have elected in the past to do some of their own urine specimen collections, and some will elect moving forward to train in-house employees to do oral fluid specimen collections, but they must get training and get qualified. The applicant or employee cannot do their own collection. So anybody doing oral fluid collections must obtain training to show proficiency in the operation of the particular oral fluid collection device to be used. And if more than one device is going to be used, they need to prove initial proficiency on each device. This is all outlined in 49 CFR Part 40, Section 40.35, which is, we've seen some renumbering of some of the sections in Part 40 because of some of this additional regulatory information. Training is not yet available because there's no approved lab and approved device yet available, and we need a device to do the initial proficiency. Training will become available, and U.S. Drug Test Centers will make that information available and make that training available as it becomes available and published, how it works and how much it costs and those kind of things. And part of that training is the monitoring of the proficiency demonstration or the mock collections. And that who can do that? So one who has regularly conducted oral fluid drug test collections for a period of at least 1 year. Well, that's nobody as of right now. One who has conducted DOT oral fluid collector training for at least 1 year. That's nobody as of right now. Or one who has successfully completed a train-the-trainer course, which we will have people that have gone through the train-the-trainer course that can help, and U.S. Drug Test Centers will provide training with those folks to get you folks that need to be trained and qualified and your mock collections monitored for the oral fluid drug testing program. Question, will U.S. Drug Test Centers send information to update our drug test policy? The answer is yes. There'll be addendums that can be produced to update a drug test policy to incorporate that oral fluid drug testing can be utilized. And we're going to talk about something, we're going to talk in a few minutes about something called standing orders. And let's hold off on that for a couple of minutes. Before we get there, let's talk about the benefits of oral fluid testing. It's an easy collection, no gender requirements. There's no bathroom required, no yuck factor, non-invasive collection method that causes minimal health and safety concerns. Employer representatives can be trained to collect specimens on site at employer premises. There's a shorter window of detection to find recent drug use, particularly useful for post-accident and reasonable suspicion drug testing. It can eliminate the up to 3 hour shy bladder wait when someone can't produce a urine specimen. And it can eliminate the uncomfortable direct observed urine collections that require a same-sex person to go in the bathroom up close and personal with the donor. So there's some tangible benefits here. What are some scenarios where oral fluid might be more beneficial? Some of the same, also remote areas where finding a urine collection site is difficult. After hours testing, when finding a mobile collector to come out is difficult. And again, direct observed collections and shy bladder urine situations. Now, the DOT has provided guidance that employers should provide something called standing orders to tell collectors what their decisions are about when to use urine, when to use oral fluid. And these standing orders, once you develop them, should be communicated on a broad basis to folks that do collections for you, to your TPA, U.S. Drug Test Centers, and to the laboratory, so that someone can easily find your standing orders. So the standing orders could be that we continue to use urine, in our DOT drug testing program, but we use oral fluid specimen collection for any drug testing that requires direct observation. Anytime a donor goes into shy bladder, after a urine specimen shows temperature out of range or appears to have been adulterated or substituted, which is going to turn into a direct observed collection. In remote areas where finding a collection site is difficult, again, employer representatives can be trained to collect oral fluid specimens. And in all cases for post-accident and return to duty testing, reasonable suspicion testing, follow-up testing, return to duty testing and follow-up testing require direct observation, post-accident and reasonable suspicion. We're looking for more recent drug use. We're looking to determine if the person is possibly impaired. The drug test doesn't tell us that, but it tells us there is more recent drug use. So if a direct observation is required and there's no standing order available, hopefully there is a standing order available to allow oral fluid, and the collector will follow that standing order. But if there's no standing order, the collector has to contact the employer, DER, designated employer representative, to determine what is the DER's choice of what to do in this collection event. Which brings us to one of the items that DOT has clarified in the revised version of Part 40 is that DERs are required to provide on the drug testing custody and control form and to the collector a phone number where the DER can be reached 24/7 or alternate DER that can be reached 24/7. The DOT wants collectors to be able to call a DER when they're doing a collection, day or night, to get clarifications, get questions answered, report issues, things of that nature. And if the DER wants the oral fluid test done, the collection site will do so if they're able to, or have to send the employee to a collection site acceptable to the employer for an oral fluid test. So very similar to currently, if you have to do a direct observation on, for example, a male, and there's only females in the clinic, what do? Well, you find somebody to do it, a male, or you send them somewhere else to get it done, or you call the employer and they come to help you get it done. Now, laboratories are going to be required to check on the device that they receive with this oral fluid specimen, check the expiration date on that device. The collector is also required to check the expiration date on that device and enter it on the custody and control form. Now, if it's not entered, the laboratory is going to check it, and if it's expired, the laboratory will reject the specimen. If it's not expired, the laboratory will note the correct date and proceed with the testing process. The new Part 40 with oral fluid testing is also requiring laboratories to provide some biannual data reporting to the DOT. Now, for the medical review officer, there are some updates to the what we call revised 49 CFR Part 40. MROs are not required to immediately undergo any type of recertification training, but it is strongly suggested that MROs seek supplemental information about oral fluid testing by the time we get the 2 laboratories certified to conduct oral fluid testing. Now, as we speak, MRO training courses are already covering oral fluid in their training courses. All MROs are required to be recertified every 5 years, and all MROs are required to have annual training courses like continuing education. A little bit of a change on bullet point number 2 here. When a pharmacy needs to be contacted to verify a donor's prescription, it was only the MRO that could call the pharmacy. The MRO staff now, administrative staff members under the MRO, may contact a pharmacy to verify a prescription that an employee has cited as a potential legitimate medical explanation for a laboratory confirmed positive test. The third bullet point here is a clarification. It's always been the case, but again, certain things are being reclarified. Sometimes MROs cancel a test because they didn't get the right paperwork. And DOT in the revised Part 40 is stating that MROs are allowed to uncancel a test that was previously canceled due to an uncorrected flaw when the flaw gets corrected. So there was some paperwork missing, or the CCF copy was missing, and they receive it later on after they already canceled the test. They can uncancel the test and start the review process again. Last bullet point here, MROs do get involved with shy bladders that go the full 3 hours. And in the case where we have what we call a dry mouth, okay, where we don't get enough oral fluid specimen, there's going to be a 1 hour period for a dry mouth. Now, if in the collection event, let's say we start with urine, they have a shy bladder, we go to oral fluid, they have a dry mouth, the physician referral that the donor is entitled to determine if there's a medical explanation for not being able to provide enough specimen will be for the second specimen type attempted. So if we start with urine, we go to oral fluid, the evaluation is going to be about providing oral fluid specimen. If we start with oral fluid and we go to urine, the evaluation is going to be about the inability to provide a urine specimen. Substance abuse professional, a few changes with the new updates to 49 CFR Part 40. Shortly after the pandemic started, COVID-19, the DOT authorized the temporary use of remote evaluations by the substance abuse professional. That has now become permanent. Substance abuse professionals can do remote evaluations with a webcam, must have technology that must permit real-time two-way audio and visual interaction between the SAP and the applicant or employee. The quality of the technology must be sufficient to allow the SAP to gather all the visual and audible information the SAP would normally observe in a face-to-face interaction. And the technology must incorporate sufficient robust security to protect the confidentiality of the conversation. This will make it easier for applicants and employees to find SAPs, because if there's not one for 60 miles, they don't have to drive 120 miles or whatever. It can be done remotely. Now, there is a caveat to that. If the SAP has some type of license or credential that restricts them to a geographical area, they would not be able to conduct evaluations that exceeds their geographic limitations. So for example, if the state licensure of the SAP says you're licensed in, let's say, California, for example, the SAP would not be able to do remote evaluations outside of California. I don't know if the California license has that stipulation or not, but if it did, the SAP must not conduct an evaluation that exceeds their geographic limitations from not only their licensure, but also their credentials, the credentialing organization that certified them to be a SAP. Okay, so a few new employer requirements with the new updates to 49 CFR Part 40. This is kind of a clarification because it's always been that it is the employer's duty to determine whether a refusal has occurred at the collection site. Employers have never been able to delegate this duty. Collectors do not make official determinations of a refusal to test. An MRO only reports a refusal when there's an adulteration or a substitution. The specimen went to the lab and the lab found adulteration and substitution. So, for example, the collector calls you and tells you the donor left after 45 minutes. They said they weren't waiting. They weren't going to do, they weren't going to wait for the shy bladder process. Or they started doing the test and they said, I'm out of here. They refused, or they refused to empty their pockets. They refused to cooperate with the testing process. Now, there are some employers, maybe some of you, maybe not, that would say, okay, I guess that's a refusal. The collector told me it was a refusal. It's a refusal. Well, it's not the collector's decision. It's the employer's decision. And it would be smart for the employer to do a little investigation, make sure they know what happened, make sure they review any documentation, and then make an official determination. Is this a refusal or is this not a refusal? There are serious consequences to someone who has a refusal on their record. So the employer needs to take charge of that decision. Some other clarifications for employers. The DERs have always been required to be available to collectors, but that's even more important now, and DOT is emphasizing that and will be monitoring and looking to see that a DER phone number is correct on the custody and control form. When they do inspections at collection sites, they will pick up a form and they'll dial that phone number to see if they can find you the DER. DERs need to be able to be available to the collector to discuss if there are problem collections. The DER should be available to discuss standing orders on what type of test the employer wants administered if problem collection scenarios arise. For example, they don't get enough specimen, temperature's out of range, and do you, the employer, want the collector to switch from urine to oral fluid or from oral fluid to urine? And this is why the standing orders and communicating those standing orders is going to be so very important in this process. Another new Part 40 additional clarification dealing with the Social Security or employee ID number or CDL license number that you record on the custody and control form or in the electronic scheduling system for a drug test. The person being tested, the donor, needs to have a unique identification number. Traditionally, it was the Social Security number or an employee or issued ID number. With the onset of the FMCSA clearinghouse for FMCSA regulated employers, hopefully we've been using the state of issue of their license, abbreviated, and then the license number with no spaces, no dashes, no special characters. So if it's Florida, it would be FL 123456789. The abbreviated state and the driver's CDL driver's license number, no spaces, no dashes, no special characters. As of now, with the new Part 40 revision, June 1st, the definition of the ID number to be used can be any other state or federally issued identification number identifying that donor. So you could be consistent and use their driver's license number for all the DOT agencies, not specifically FMCSA, if you've elected to do so. So this is a change because of the reluctance of folks to use their social security number in an open setting like a medical clinic, and also a lot of people using the last 4 digits, which should never have been used because that is not a unique number to identify an individual. So whatever you're going to use to identify your applicant or your employee, it needs to be the full number, and it can be any state or federally issued ID number or an employer issued ID number, or the social, which is a federally issued ID number. A couple of other new Part 40 additional clarifications, but just an FYI, this is my last slide. So after this slide, we'll open it up for questions and we have answers. And I don't have any current questions in the queue, so now's the time to be thinking about some questions, because we do want to answer any and all of your questions. Okay. So we talked about the DER must provide their accurate phone number. The collectors in this process must also provide an accurate phone number that will ring to the collection site. The collector must not provide a corporate office number or a call center number. You, the employer, the MRO, the laboratory, DOT staff may need to speak with the collector. And the telephone number that the collector provides on the custody and control form must give access to that collector or that collector's supervisor. Second bullet point deals with what we call error correction training. When a collector makes a mistake that leads to a fatal flaw and the test is canceled, the collector is required to have error correction training. In the past, when the lab got specimens and they were leaked, somehow, somewhere they leaked, there's water in the bag, not in the vial, the collector was blamed. And the collector said it was sealed when I put it in the bag and I gave it to the FedEx guy or I gave it to the courier. Why should I be punished? Because it leaked in transit. So DOT is saying that the collector will not be subject to the time and cost of retraining for errors that occur outside the collection process, such as in transportation. ODAPC, which is the Office of Drug and Alcohol Policy and Compliance, a part of the DOT that provides guidance and interpretation of the DOT regulations, will be publishing an ODAPC oral fluid specimen collection guidelines document, or actually it's kind of a booklet, a publication, separate from their current urine specimen collection guidelines document. Once that is available, that will be the basis for oral fluid specimen collection training, which we will provide and make available to folks like you. So let's go ahead and open it up for more questions. I do have one here, and then we'll go to any others. If a donor leaves the collection site, is a canceled test an option in place of a refusal? So that's a good question. So the question is, why and when did the donor leave the collection site? And that's the documentation that you as the employer should get from the collector, and you should review it. So they're in shy bladder, they can't urinate, there's no standing order to go to oral fluid, and an hour into it, they say, I don't have time for this, I'm leaving. Well, yeah, that's going to be a refusal, okay? But it could be a unique situation that upon investigation an employer could verify. Let's say the donor said, I got a text from my wife. My son was in a car accident and on his way to the emergency room. We're not going to call that a refusal, but we are going to verify that that happened. Okay. Because I can tell you that I worked as an expert witness on a case in a trial, and that's what the donor said, and that never happened. There were no records, there was no child that had to go to the emergency room, there was no car accident. So you verify it, you investigate it, you get the documentation. As an employer, you make a good faith determination. Another great question. How do we issue standing orders with the collection site? So, a couple of different ways. If you use the same collection site all the time, you send them a fax or an email and you say, we're XYZ company. These are our standing orders. If you use paper custody and control forms and you're sending somebody out to a collection site, and maybe it's not one that you use all the time, maybe you send the standing orders with that paper custody and control form. You provide the standing orders to your consortium/TPA, like U.S. Drug Test Centers, and they help to communicate the standing orders to your collection sites. We anticipate and hope, and I can't promise this, that the laboratories will allow you to have your standing orders in their system underneath your account number. So the laboratories have your account number, they have information about who you are in your account. So maybe it would be a good idea to have them put the standing orders there so that if somebody goes into a Quest facility, they can pull up the standing order. If somebody goes into a LabCorp facility, they can pull up the standing orders. But the bottom line is, how do we communicate the standing order to the collection sites? Any way that we can and every way that we can. Because otherwise they're not going to know what they are. And they're going to be trying to call you all the time. Okay? Next question. I understand that at least 2 labs have to be approved for this new testing to be utilized. Are there going to be more than just 2 labs eventually? Yes, more than likely. There'll probably be a half a dozen, more than likely, but I can't promise you that. But I would guess that eventually Quest Diagnostics, LabCorp, Alere, clinical reference laboratories, at a minimum, those laboratories will get approved and certified. Is it true? Next question. Is it true that one of the purposes of the oral fluid testing is to permit marijuana use within a certain period of time before work and/or testing? I read that the test only detects marijuana usage within the last 2 or 3 days and not any longer. For example, if you used marijuana 1 week ago, it would not be detected on an oral fluid test today. So that last statement is more than likely true because oral fluid testing is going to be detecting usage, not just marijuana, but any of the drugs, pretty much from ingestion up to maybe 2 days. Not an exact science, just like urine testing, not an exact science. Okay. So one of the purposes of oral fluid testing is to detect more recent use of the drugs. That is a true statement. To detect more recent use of the drugs. And in the case of marijuana, it's detecting the parent drug, not the metabolite. So there's an argument that this person just recently used marijuana. The argument against metabolites in certain states that are passing laws that say you can't discipline someone for what they do on the weekends, and in DOT you can, by the way, but for non-DOT, you can't discipline someone for something they do on the weekends. So therefore, you can't discipline them based on a positive on a THC metabolite because you don't know when they use the drug. And there are states like New York and New Jersey and California as of this coming January, and the state of Washington as of this coming January, that have laws like that for non-DOT testing. And with urine testing, we are only detecting metabolites, something that was ingested into the body and broke down in the body. But with oral fluid, we're testing the parent drug. And so there's an argument that with oral fluid testing, we can still test and still take disciplinary action on marijuana in that non-DOT setting in those states that have what we call employee protections. The next question, is there a cost difference between the tests? So excellent question. So when you get a drug test done, there's a cost for collecting the specimen. There's a cost for the lab work. There's a cost for the review by the medical review officer. More than likely, you pay one fee, but it includes those three cost factors. If you do the specimen collection yourself, the cost is going to be less because there's only two cost factors, the lab and the medical review. Now that's with traditional urine drug testing. And with traditional urine drug testing, the collection device is a little plastic cup that costs about 2 cents. And the labs provide those cups to the collection sites, so there's no additional cost for those cups. So you pay a collection fee, a lab fee, an MRO fee. More than likely all rolled up into one bundled fee. With oral fluid testing, there are four cost factors. There's the cost of the collection device itself. It's not something that's 2 cents. It's multiple dollars worth of cost, and there's going to be a charge for it. There's the cost of the collection. There's the cost of the lab work. There's the cost of the MRO. So in that example, oral fluid testing, the total cost could be more than what you're paying for urine. Maybe $5, $6, $7 more. Now, if you do your own collection, the cost is going to be less, just like if you do your own urine collection. But you still got to pay for that device if you do your own collection. But you're not paying the collector. You're paying some, you're absorbing your own internal labor cost. So the bottom line is there a cost difference? Yes, there is a cost difference. Is it a major factor? No, but got to pay for the device. So employers have to make decisions. You need to start thinking about your decisions and what your standing orders will be. Can you stay with urine? Yes, you can, except for that direct observation collection with a non-binary or transgender identification. Can you go all oral fluid? Yes, you can. Easy collection, no bathroom requirements, no specific gender requirements when we have a direct observation. All oral fluid tests are direct observations and there's no gender requirements. So we got time for more questions, but I want to put up on the screen the handouts. There's two handouts. Callie will email them to you today or tomorrow. One is a copy of these PowerPoint slides. The other is a one-page sheet, kind of tips of what you need to know, okay? And then you'll get an email directly from the GoToWebinar system with a certificate of attendance and a recording. get that later today or tomorrow. Check your spam. If you don't have it by noon tomorrow, then you can reach out, but check your spam first. You see Callie, Director of Client Services for U.S. Drug Test Centers. The phone number, the email address. Callie, do you want to add anything while we're waiting on any more questions?
Yeah, thank you, Joe. I just want to say thank you everyone for joining the webinar. We hope you enjoyed it. As Joe said, please send as many questions, concerns, feedback as you can my way. Feel free to reach out via phone or email. The feedback definitely helps. It helps us continue these webinars. So we hope you enjoyed. And if you have any other last minute questions, please send them our way so we can get those answered before we sign off. And then again, as Joe said, please be expecting an email from me today or tomorrow at the latest with the handouts. Thanks, Joe.
Okay, great, Callie. And we'll stay a couple more minutes. If you do have any more questions or any feedback, if you thought this was good, bad, indifferent, you got any complaints, you got any compliments, we'll take all of those in the questions box also. And we'll just kind of wait to see if we have any more questions for a couple minutes. Appreciate all the feedback very much. And keep in touch and make some employer decisions. Get with your leadership. It's going to be important. And with that, I'm going to sign out. Have a great rest of your day. Thank you very much for your time and attention.